The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 563-503-6910. That's 563-503-6910. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. Thanks again for watching and listening.
Hi, this is Andrew with Learn About Law, and in today's video we discuss how an executor, that's the individual or entity responsible for managing the assets of a decedent's probate estate, should handle real estate assets during probate in Iowa. With help from an attorney, it is the executor's responsibility to inventory all the assets of the decedent, including all property. In Iowa, the personal representative or executor must file a report and inventory all the property of the decedent within 90 days of being qualified. An extension can be granted by the court as needed. The executor should not take this responsibility lightly, as the inventory will be verified by an attorney under penalty of perjury. Once the property is properly inventoried, it will be appraised, sometimes by a certified appraiser, depending on the category of property. Also, this information will be available for creditors. If the property is to be sold to pay debts, it will be listed at fair market value. If the property is exempt from probate or cannot be used to pay debts, it should still be inventoried. If an explicit will or trust is not present, the personal representative should begin by searching for items such as a deed, mortgage, papers, or real estate tax bill. The personal representative can also search through the decedent's income tax return for mortgage deductions or real estate tax deductions. The attorney can also run a title search for the decedent's name or any names associated with a trust containing the property of the decedent. Generally, if a piece of real estate property was owned individually by the decedent and is not listed under a trust or jointly owned, it will go through probate. Property covered under a trust will be distributed according to the terms of the trust. If the property is jointly owned, for example, a married couple jointly owns their home and the deed states that the other person has the rights of survivorship over the property, it will pass directly to the other person without going through probate. If a will or trust is present that explicitly states what to do with the real estate property, it should definitely be followed. Assuming that the estate's creditors have been satisfied, if there is no will or trust, or the will and trust do not explicitly state what to do with the real estate property, the usual action would be to sell the property at fair market value and distribute the funds to the beneficiaries. However, before selling any real estate, it's best to get input from the heirs and/or beneficiaries. They may have already reached a more amicable distribution of the real estate property, such as having one person inherit the property but receiving less monetary funds. One or more of the heirs may also want to purchase the property directly from the estate. This can help when paying down debt owed by the estate. In any of these situations, the executor should get a signed copy of the agreement between all the heirs and beneficiaries. In the state of Iowa, the personal representative is required to take control and possession of all the decedent's personal property. The personal representative should continue to upkeep property under the estate not already owned by the beneficiaries, jointly owned, or that which passes outside probate directly to the beneficiaries. If the executor does not sell or transfer the decedent's real estate property during the administration of the estate, the executor must send a notice of probate to the county recorder's office in the region in which the real estate is located. The executor should also determine if the mortgage on any property going through probate has an acceleration clause before selling or transferring the property. As always, thanks for tuning in.
Hi, Kevin O'Flaherty again. Hope you enjoyed that presentation of Learn About Law presented by O'Flaherty Law. If you need some help, please give us a call, 563-503-6910. 563-503-6910. Again, we offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.